Hello, everyone, and welcome to today's webinar, kindly hosted by the British Institute of International and Comparative Law. I am Dr. Constantinos Yiallourides, and I will be chairing today's session. We will be hearing from leading experts, whom I will introduce shortly, their impressions of the landmark, or some have called it a historic advisory opinion issued by the International Tribunal for the Law of the Sea earlier this month, and what this means for the future of climate litigation efforts. As a background, and as many of you would know, on 21st May, ITLOS delivered an advisory opinion on states' obligations to protect and preserve the world's oceans from climate change impacts, such as ocean warming, sea level rise, and ocean acidification. This is the first time that an international judicial body has addressed states' obligations to combat climate change within the framework of the UN Law of the Sea Convention. The tribunal found unanimously that anthropogenic greenhouse gas emissions absorbed by the oceans constitute pollution of the marine environment due to their harmful effects on marine ecosystems and marine life, and that accordingly states have specific obligations to mitigate, control, and eventually eliminate such pollution to the maximum extent possible. ITLOS is also the first international body to deliver a climate-related advisory opinion. The Inter-American Court of Human Rights and the International Court of Justice are also expected to issue climate-related advisory opinions in the coming months. What is more, hundreds, if not thousands, Ivano will tell us, climate litigation cases at the domestic level are ongoing across multiple jurisdictions. Those cases are seeking to hold governments and or corporations into account for inadequate climate action. So I think it's fair to say this much awaited advisory opinion has generated significant attention, both in legal and academic circles, but also in the mainstream media. There are many discussions, many events, many commentaries, including from our own speakers today and also on the BIICL website. Now, this is how today's webinar will run. I will briefly introduce each speaker in turn, and each speaker will provide their initial remarks for 8 to 10 minutes. Then we will aim to have approximately 30 minutes for follow-up questions and Q&A questions with you. So if you would like to ask the panel a question, then do please feel free to type in your questions in the Q&A chat. And at the end, I will choose a few questions within the time we have to read them out to the panel. So I would like at this stage to thank my colleagues, Christine, Liam, Jean-Pierre, and everyone at BIICL for assisting this event, and of course, our wonderful panel for joining us today. And also please note that today's session is being recorded. Now, without further ado, please allow me to introduce our first speaker for today, Professor Christina Voigt. Is a professor of law at the University of Oslo in Norway, a renowned expert in international environmental law and chair of the IUCN World Commission on Environmental Law. She has worked as a legal advisor and negotiator for the government of Norway in the UN climate negotiations, and is currently the first co-chair of the Paris Agreement's Compliance and Implementation Committee. Christina, we look forward to listen your reaction to this advisory opinion. Thank you very much.
Well, thank you very much, Constantinos. Thanks to BIICL for organizing this very timely discussion, first take on the rather fresh advisory opinion by ITLOS from just last week. And thank you so much for inviting me. It's a great honor. Just for reasons of transparency, I would like to mention that I was the lead legal counsel for the IUCN in the proceedings at ITLOS. IUCN is an intergovernmental organization, and we were invited by the court to participate. But I think the observations that I share here today are in my own personal capacity. I'm not speaking here on behalf of the IUCN. Well, I think, as you already indicated, Constantinos, there have been many reactions to the advisory opinions, calling it historic, is something that really pushes the international climate law to a new universe. I refer to it as a remarkable opinion. I think it went far beyond much what many commentators expected. And I do think that the 21 judges in Hamburg really staked out policy and legal work for many, many years to come. I have prepared 8 very brief points, which I personally think are very important to note. The first one is one that you already mentioned, Constantinos, that it was a unanimous opinion, right? It was signed by all the judges. There was no dissent, there was no disagreement. And I think this is truly remarkable. When I went to the website and saw that there were 5 declarations by judges, I thought, oh, maybe some of the judges had an issue with this or that. But no, the declarations are really interesting to read because it seems that some of the judges wanted to go even further and include considerations of human rights into the deliberations in the advisory opinion. So it was really an interesting and remarkable opinion in this regard. The second point is, of course, the core legal finding that anthropogenic greenhouse gas emissions fall under the definition of pollution, either directly as gases and thereby as substances, or indirectly by contributing to global warming as energy. And that has, I think, in my view, the most far-reaching consequences. First of all, because it covers all sources of greenhouse gas emissions, including those from land, right? From territories of state, that can be even landlocked states that do not have any access to the marine environment. But now the definition of pollution, because it covers any sources, is applicable to both marine activities, but also land-based activities that have an impact on the marine environment. So I think that has incredibly far-reaching consequences. The third point is, of course, by finding that greenhouse gas emissions are pollutants or is pollution, that opens the legal gates to Article 194 and determining what the legal obligations of states are under ITLOS. And here the tribunal is very clear that states must take all necessary measures to prevent, reduce, and control pollution under Article 194, paragraph 1, and avoid transboundary harm to other states in the marine environment under Article 192 and 194, paragraph 2. And interesting, the tribunal sets up factors that are relevant in assessing what all necessary measures are. And there are 2 factors, right? One factor is science, and the tribunal very consistently refers to the IPCC report. And the other factor are relevant international rules and standards, where the tribunal directly then goes to the UN climate treaties, the United Nations Framework Convention on Climate Change, and the Paris Agreement, and defines them as the primary legal instruments addressing climate change. And it refers that, in particular, the temperature goal of the Paris Agreement and the corresponding timelines for emission pathways are relevant in informing the content of what are necessary measures under Article 194 of the Paris Agreement. Interesting of UNCLOS. Interesting in this regard is that the tribunal only focuses on the 1.5 degree target, but it doesn't even mention well below 2 degrees. It is 1.5 degrees that matters. I think that that's an important underlining of the legal relevance of that temperature goal in Article 2.1a of the Paris Agreement. It is then going on, as we all know, to determine the nature of this obligation as one of due diligence. That is not surprising. We know that this is the case. But what is helpful is that the tribunal sets up a number of factors that help us to determine what that due diligence implies. And it actually determines that against these objective criteria, right? It says due diligence is not anything goes, but it has to be determined on an objective basis. And the criteria are the risk of harm, the urgency involved, the scientific and technological information, as well, again, relevant international rules and standards. And if you apply all this, or the tribunal applied all this, it came to the conclusion that we are here looking at due diligence of a particular stringent nature. And when it comes to the transboundary obligation under Article 194, paragraph 2, it is even more stringent because it affects other states. So here we are dealing with a heightened level of due diligence in the obligations of states to take all necessary measures. A fifth point is how the tribunal deals with differences between states, right? Differentiation, which is a contentious issue, a very difficult issue in the climate negotiations. And here the tribunal gave us a very important pointer on how to deal with the fact that states are different, and we have to take account of these differences in determining the necessary due diligence. And it says, well, basically, due diligence may vary according to states' different capabilities and available resources, which requires that states with greater capabilities and sufficient resources will have to do more than a state not so well placed. So it focuses on capabilities and resources, right, rather than responsibilities. But it also says, and that's very important, that that doesn't excuse any states from doing the best it can. It says, nonetheless, implementing the obligation of due diligence requires that every state has to do whatever it can in accordance with their capabilities to reduce marine pollution. I think that's an important finding on that issue of differentiation. My sixth point is the tribunal's important approach to establish a systemic approach to international law, trying to integrate different fields of international law in an attempt to create harmony and coordination. And it says, of course, by looking at other treaties that are relevant, they have to be interpreted consistently with UNCLOS. And the external rules, and it refers to many different external rules, in particular climate treaties, but also the Chicago Convention, MAPO, the Montreal Protocol, Kigali Amendment, CBD, many different treaties. And it says very clearly that these rules need to be taken into account when interpreting UNCLOS, and that they're not lex specialis. However, and here I'm a little bit critical to what the tribunal did, because when it comes to the Paris Agreement, where the tribunal says parties cannot just by simply complying with the Paris Agreement fulfill their obligations under UNCLOS, it seems that the tribunal took a very minimalistic view of what the Paris Agreement requires, right? It seems to suggest that it's only a formality and everything is up to parties. And that is unfortunate, because one would have expected that the tribunal delves a little bit deeper into the legal architecture of the Paris Agreement, looks at the normative parameters of progression and highest possible ambition that parties have to put in their NDCs, in particular, given the very important deadline next year in 2025, where every single party has to put forward a new NDC, which is progressing beyond its current one. So I think that that very limited understanding of Paris is rather unhelpful, because it suggests that parties under Paris, that's simple, but under UNCLOS, that's really, really hard. And that kind of undermines what is now required of parties to comply with their obligations under the Paris Agreement. And my seventh and almost last point, my eighth point, that's the last point, is the interpretation of Article 192. That's the more general obligation, which says states have the obligation to protect and preserve the marine environment, has been interpreted by the tribunal to primarily focus on adaptation measures, right? On adaptation measures, particularly to preserve the marine environment, to protect ecosystem health, to protect the natural balance of the marine environment, even to go so far as to restore degraded ecosystems due to the impacts of climate change. I think there are also potentially far-reaching consequences, legal consequences, in this interpretation of Article 192 in the context of climate change. To wrap up, I think in sum, it is, as I said, a remarkable decision because it provides a clear confirmation by the tribunal that UNCLOS is a legal basis of states' obligations to address climate change, both mitigation and adaptation. I think that's very important. We know now UNCLOS provides a legal basis, in addition to the European Convention on Human Rights, as we know from the European Court on Human Rights, alongside the climate treaties that actually sets out climate obligations, right? And they sit alongside, they're not lex specialis, they look into each other in a way by interpreting the relevant terms. And I think the repercussions of that advisory opinions will still have to be studied, and they still will be, I think they will be seen for many years to come and in very many different contexts, right? Whether it is domestic courts picking up on what came from Hamburg, whether it's influencing, which I personally hope, states' ambitions, what they put in their NDCs next year, that it is being used as a push-up for increasing ambition under the Paris Agreement, but also for decision-maker domestically, but also not the least for the other international courts that you mentioned, Constantinos, in particular the International Court of Justice, but potentially also the Inter-American Court on Human Rights, in their advisory opinions on states' obligations on climate change, again, to create a harmonious understanding of states' obligations and not create even more fragmentation than what we already have. I think with that, I thank you for the opportunity to share my thoughts and turn the floor back to you, Constantinos.
Wonderful. Thank you so much, Christina. That was really excellent. It gives me now great pleasure to introduce our second speaker, Monica Feria-Tinta. Monica is a barrister at 20 Essex, a specialist in public international law and international arbitration, and a leading expert in climate change and environmental litigation, among many other fields. She has acted before multiple international courts and tribunals and has also published extensively on various specialist areas of international law. So great to have you, Monica, and the floor is all yours.
Well, thank you very much, Constantinos, for the invitation and for the kind introduction. I'm delighted, to be today having to discuss this advisory opinion because it was a foresight and a dream some years ago to actually have this delivered by a tribunal like the Tribunal on the Law of the Sea. So I still have fresh in my memory 2018, the first time that I stood and in front of an audience and I believe for the first time made the point that the issue of climate change should actually reach international tribunals. And together with Professor Alan Boyle, were instrumental to actually bring that in front of small island states in COP28, actually. And from that moment on, there was a journey that I think has, taken us now to this moment. So a couple of remarks on procedural things. I think that first of all, what is interesting, hasn't been mentioned yet, is the fact that the tribunal dealt with this matter within a period of 1 year and 5 months. Well, that is remarkable. I think that really is interesting because it shows how effective the procedural aspects can be when it has to do with adjudication, with dealing with complex matters by an international tribunal, which we cannot take for granted. It shows the manner in which the tribunal took this as an urgent issue. And by way of comparison, the Human Rights Committee, when it dealt with the Torres Strait case, it was over 3 years, despite, our constant calls, and I was counsel in that case, for speediness. So I think that is something that we have to acknowledge to the tribunal, how efficiently it dealt with this despite its complexity. It has already been mentioned, the unanimous issue, and I think that's also a highlight in terms of the procedure. The participation was also interesting because obviously we had not only the state parties, the tribunal recorded 31 state parties, but also the intergovernmental organizations and a wide number of NGOs. I was instructed by WWF and made a number of submissions that have been reflected also in the advisory opinion. So there was very broad participation. Now, the first remark on the substance is perhaps the fact that up to this point, it would have been unimaginable that a old treaty, 40 years old, could possibly be interpreted in a manner as it has when it doesn't contain the term climate anywhere in the convention. So UNCLOS doesn't mention climate, and yet we have had this decision. And the question is why? And here, I mean, I share with you, Constantinos, that I have written this article that is going to come out on the Cambridge Journal of International Law on treaty interpretation. And I think something that is crucial and is going to, be subject of a lot of thinking and studies is the manner how the tribunal has applied the Vienna Convention, the law of treaties, interpreting this particularly all treaty, and concluding that Article 114 and the term pollution implies and contains, they construe pollution in a manner that it takes into account all kinds of sources of pollution. And in fact, these and focus on GHG as one of the primary forms of this pollution, and cover the whole ground of possible sources. Christina named land-based sources, but also aircrafts and vessels. And I think this is important because it really covers the whole possible worldly dimension of where pollution of this sort can come from. Let's not forget the impact of that, because 70% of, generally speaking, 70% in the world is constituted by oceans. And this is major when we think in terms of the applicability of UNCLOS, and now the broad scope of all these obligations is basically covering, 70% of the world. And that's, if you see that in percentage times, that means that, we have now a path to regulations under the obligations of UNCLOS that cover with clarity this dimension in the world. So moving on from that, I just would like to make a couple of other remarks. First of all, on science. The tribunal follow the structure in the process of thinking the particular questions started by the science, and plays a crucial, put it central stage. Science occupied a very important role in the thinking of the tribunal. And it actually said something very important. At paragraph 56, ITLOS observed that none of the participants had challenged the authoritative value of the IPCC reports. This is really important, and as we may discuss later, it's going to have an impact for all the other tribunals, because this has been unchallenged. Let's not forget how many parties are parties to UNCLOS. 168 states. So this, in a way, is relevant for all these state parties to consider. So this is the starting point. Now, the other starting point for the court also was that it was not starting from zero. It was starting from an acknowledgement, and he mentioned the declaration by the 2022 United Nations Ocean Conference, where it was stated that the conference was deeply alarmed by the adverse effects of climate change on the ocean and marine life. So the path to the due diligence test that Christina enlightened us with is basically starting from an acknowledgement of a high risk, of an emergency situation, of an urgency, and of an acknowledgement that there is a number of effects, such as sea level rise, increasing ocean heat content, marine heat waves, ocean oxygenation, and ocean acidification. So I think this really then is going to affect and in a way be very relevant in what way, starting from that point, the obligations are read, particularly interpreting the relevant provisions of UNCLOS. Just a couple of points on that. One is the important focus that the tribunal makes on the issue of transboundary harm. To me, that is absolutely revolutionary and key, because we haven't had so far any international tribunal that has clearly discussed, addressed, and actually held the rule when it comes to transboundary harm on the issue of climate. So far, the Torres Strait case dealt with non-transboundary harm because the victims were within the jurisdiction, territorial jurisdiction of the state that was held responsible. And we have seen what the European system has done with the issue of transboundary harm. So this is a clear statement in terms of what are the obligations of the states in that regard, and is to ensure that activities within the jurisdiction and control respect the environment of other states and of areas beyond national control. That is extremely interesting. And why? I mean, and if you control, and it's not little what you have to what you control. You control land-based sources. You control aircrafts. You control shipping. You know what you control. Well, that is what you have to bear in mind. And it refers to activities that are carried out not only both by public, right, action, but also private actors. And this is something that the third speaker is going to refer more about, the private actors. But I place, here, I already flagging that importance because it's so comprehensive. In a simple language, it really made a very comprehensive point. Now, concerning this issue on treaty interpretation, whether the convention goes beyond or not, I think it's a point that was raised by Von Law quite well. Von Law was in his submissions on behalf of COSIS put it very clearly, and I totally agree with his analysis. And basically, it was that the language of UNCLOS was very clear. For example, here we are seeing that the tribunal has asserted that there is an obligation of cooperation. And this is an obligation, whereas there is a language that exists in the Paris Agreement that may be different from the language contained in UNCLOS. So you have in UNCLOS language like shall, and you have in the Paris Agreement at points language such as should. And this is, I think, important that at least 168 states have even more stringent obligations under UNCLOS, the parties that are parties to UNCLOS. So in that sense, I think that it was important that it's important also for other, it's going to be important for the interpretation of other treaties. But I think not only was relevant for cooperation, but also for issues of reparation and state responsibility, which is something obviously Paris doesn't deal with. And here the tribunal was quite clear. He said, well, we haven't been asked about secondary rules. We haven't been asked about, but if states do not comply with these obligations, that may entail state responsibility. And it was already entailing, it was highlighting the possibility that breaching primary rules will have legal consequences. And it's already there, linking us to the situation what we may see later with the ICJ But okay, I will stop there, and I hope that we can discuss a little bit more about some of these points I've been raising.
Thank you very much, Monica, for your remarks. That was brilliant. I will now hand the floor to our third speaker and my good colleague at BIICL, Dr. Ivano Alogna. Ivano is the research leader in environmental and climate change law at BIICL and a licensed attorney at law at the Bar of Milan. Ivano is leading the Institute's training and research projects on climate change and climate litigation. So Ivano, you have the floor.
Thank you, Constantinos. Thank you very much. Good morning, everyone. It's really a pleasure, an honor also to be part of this panel discussion with these amazing co-panelists. So thank you, Christina and Monica, for your precious insights. I would like to offer my contribution by kicking off a topic that has been less considered in this first day of discussion on this, as Constantinos said, historical advisor opinion. So it has been less discussed. It lies outside of the questions to the tribunal related to the state obligation. So it's possible future connection and impact on corporate climate litigation, so on climate litigation involving corporations. If you are familiar with our climate change work at BIICL, you probably know that we launched a new knowledge platform called the Global Toolbox on Corporate Climate Litigation at the end of March. Otherwise, you can find here, the link to the webpage. So this is a little bit the outcome of a broader comparative research project that involves more than 200 experts on 17 legal systems in every continent. And at BIICL, with this group of excellent experts, we analyze the causes of action, the procedure and evidence, and the remedies that have been used in each target countries. Also, we try to see the main challenges encountered and the prospect for this fairly new but also rapidly growing field of litigation. So in the last years, there has been really a surge in climate litigation. Not only the governments, against the governments, you probably know we have now more than 2,500 cases against governments around the world. And this is something that we know from the databases at Sabin Center, Columbia University. But there are also many interesting cases against private actors, such as fossil fuel firms and other polluting industries. And many cases challenge corporate inaction on the climate crisis and attempts also to spread misinformation from them. So companies are increasingly recognizing this kind of litigation as a risk. Is really an exciting field. So at this point, as I said, we have many cases. There are currently more than 200 corporate climate cases around the world. Without counting those in the US, it's where we found some of the very first cases brought against corporations by local and national governments. You certainly remember the famous village of Yiallourides versus ExxonMobil in 2012. And now we have some new ones, like the new action filed in September by California against Exxon again, and other fossil fuel companies. So this is a field that I'm not going to spend much time to discuss. It's just to tell you, for example, the landmark example that I'm pretty much sure you all know, the first successful case of this kind of litigation, the Emilio Difensi case versus Royal Dutch Shell, which is based on the duty of care provided by the Dutch Civil Code, as further informed by the Article 2 and 8 of the European Convention on Human Rights. So this is a very important case. In the first instance, the Hague District Court ordered Shell to slash its emission by 45% by 2030, relative to 2019 levels, across both emission from its own operation and emission from the use of the oil it produces. And Shell, of course, appealed the decision, and the case was heard by the Court of Appeal last month. So this is something that you should check. And why this is important, because I believe the ITLOS advisor opinion can be really a pivotal reference in ongoing and also future climate litigation involving cooperation across various jurisdictions. And these in different regards. First, I would say the advisory opinion reinforces the international legal framework, as was well said by Christina and also Monica, that all the states, but also the entities, the private entities accountable for environmental protection, it can be cited in national courts to argue that corporations have an international duty to mitigate their climate-related impacts. So this is prospects, but moreover, and this was explained by Christina earlier, it's also quite interesting by applying external rules in interpreting ITLOS. There is the case, of course, of the NFCCC, the Paris Agreement, another treaty that you find in the text of the advisory opinion. ITLOS aim to enhance the harmonization and coordination between different international treaties and custom, and to address this very important fragmentation of international law that we have witnessed so far since, let's say, the beginning. So this would contribute in a way to respond more effectively to the complexity of climate change related issues, and also the tribunal's finding that determining what constitutes necessary measures is objective, is based on the best available science and international agreed rules and standards, as was already said, and this has potential implication. This could weaken, for example, arguments based on the broad discretion afforded by to states, and on the other side can strengthen arguments in favor or reducing such broad state discretion. So this is the first point. The second point is the corporation may face increased scrutiny regarding their environmental due diligence. So the very opinion underscores the necessity for companies to assess and mitigate the contribution to marine pollution and climate change, knowing that, again, as usual, the question was asked concerning the obligation of states. However, the opinion can also influence court to impose stricter liabilities on corporations, leading to higher compensation for damages caused by environmental degradation and climate impacts. And moreover, the tribunal's findings regarding the already cited Article 194 second of UNCLOS could have implication for climate change related litigation, and specifically the requirement the state take all the measures necessary to ensure that activities under their jurisdiction or control do not cause damages by pollution, as well as potential responsibility for any pollution arising from incidents or activities under their jurisdiction or control. As also Monica was saying, this is something that extends to both public and private actors. So this means that states might also act appropriately to ensure that the activities of any private entities within their jurisdiction or control that cause anthropogenic greenhouse gas emission are effectively regulated. The findings adds even more pressure on states to strengthen scrutiny on the activities of major carbon emitters in the country, as they could face UNCLOS-based legal challenges from civil society for example, lax regulatory standards or deficient oversight and enforcement. Third point, eventually the government may revise regulatory frameworks to align with the ITLOS advisory opinions, and in a way this could lead to stricter environmental regulation and enforcement mechanism impacting corporate operation. And let's say by anticipating legal and regulatory shifts, corporations might proactively adopt more rigorous environmental policies and practice to comply with these evolving standards and mitigate litigation risk. So the tribunal, the ITLOS, outlines specific pollution-related obligation, including, as you saw already in the text, enacting and enforcing laws to control marine pollution from greenhouse gas emission, and these standards may improve legal arguments in domestic climate litigation when a state's climate policy is challenged as insufficient to satisfy the Paris Agreement temperature goals. As Christian said, now we're talking about 1.5. So this is also an advancement, normal advancement. So in the same way that international climate change law, like the Paris Agreement, used to show that a state isn't doing enough, UNCLOS specific obligation to make and enforce enough laws and rules to stop anthropogenic greenhouse gas emission from polluting the marine environment could also be used So among these obligations, of course, we have the UNCLOS Article 206 that mandates state party to conduct the environmental impact assessment for any planned activity causing significant pollution or harmful challenges to marine environment. So the assessment might be conducted by state parties under control, and the results must be reported, and this requirement could lead to climate litigation in domestic courts. So claimants could argue that failure to conduct adequate environmental impact assessment for activities contributed to significant greenhouse gas emission violates the specific obligation under UNCLOS, and so reinforcing cases against states, but also against corporations. So to conclude, we can just say that ITLOS advisory opinion represents really a significant milestone in this quest that has been started years ago for many years ago, for environmental climate justice, and potentially also significant implication for companies. And the opinions underscores also the evolving regulatory landscape concerning climate responsibility and points to heightened scrutiny and regulatory enforcement concerning greenhouse gas emissions and environmental preservation. So the companies operating in sectors with significant environmental footprints, as we said before, the carbon majors, but also other polluting companies, must anticipate the likelihood of regulatory changes and be prepared to proactively adapt their practice to align with evolving standards. The opinion really adds to the growing body of international case law, which claimants in domestic court litigation might rely on when seeking to hold companies accountable for climate change. I stop here. Thank you for your attention, and I look forward to any questions.
Thank you very much, Ivano. That was great. So it feels to me that this advisory opinion is ITLOS's own warning to high-emitting states parties and their corporations to bring emissions down or face costly environmental and climate litigation. It feels from your comments that it reinforces what we already have. Now, without further ado, we still have about 20-25 minutes for questions, and we do have a lot of questions in the chat. So I will do my best to squeeze in as many as I can. Perhaps I will combine a few. So with the order that we started the initial remarks, a question from Sophia for Professor Voigt. What would ITLOS, in your opinion, could have done better in linking UNCLOS with the climate regime, specifically the Paris Agreement? So that follows from your comments. I believe it was 0.5 of your comments. Please.
Yeah, no, very good questions. Many thanks for that. As I said, when the tribunal looked at the Paris Agreement in its exercise of giving meaning to the terms of UNCLOS, it only looked at two elements in the Paris Agreement. It looked at the temperature goal in Article 2.1a, and it looked at the timeline for emission pathways that corresponds to the temperature goal, which we find in Article 4, paragraph 1, which is basically net zero CO2 emissions by 2050. Now, the Paris Agreement has more than those two provisions, right? There's more in the Paris Agreement that could have been used to interpret or to give meaning to the concept of all necessary measures. In particular, for example, that for developed states, their NDCs have to be absolute economy-wide targets. That's very important, has to cover the entire economy. But also that NDCs have to progress every time they're being put forward. And they have to be at the level of the highest possible ambition, which might have been very interesting to draw in this normative parameter in the determination of all necessary measures. Also, that states' NDCs shall be informed by the outcome of the global stocktake, which was a very important decision from last year's climate meeting in Dubai, where we all talked about the transitioning away from fossil fuels in the energy system, but also many other elements that we have in that decision, which are legally parties are legally required to take into account when defining the ex-NDC. So there are many normative parameters in the Paris Agreement to which the tribunal could have referred to in its exercise to determine what are all necessary measures or what is the level of due diligence. But it only confined itself to two without really explaining why only those two and none of the other normative parameters. If the tribunal had done that, if it also had included progression, highest possible ambition, and so forth, it could have created an even higher harmony between the two agreements and consistency. And it perhaps would also have been obvious that it's not so simple to comply with the Paris Agreement, as it can be read out of the opinion, which says that simply by complying with Paris, you cannot comply with UNCLOS. But it is not so simple to comply with Paris. There's a lot of effort that parties now have to put forward, and that every 5 years from now on. So a bit further engagement with Paris perhaps would have been helpful in determining what exactly is the relationship between those two instruments. Thank you. Back to you.
Thank you, Christina. Now, I'm looking at the Q&A.
Constantino,
yes.
can I just add something to that?
Yes,
very brief before you move on to a different topic. I mean, I actually see the point of Christina, but I disagree that the role of the tribunal was to, in any manner, to interpret Paris, in a comprehensive manner. And I think they tried to avoid that for a reason. And in fact, if we look at what the tribunal was asked to, was to answer specific questions of UNCLOS. I believe that in terms of the outcome, they would have not ended somewhere different. By comparison, the ICJ has a different task, and it's possibly there where what Christina suggests is going to be more of an issue, because the sources there are not in the same way that the sources were in the ITLOS process. ITLOS had to interpret only UNCLOS and use that in its normative environment, so other treaties, in what the tribunal thought it was relevant. But the ICJ has actually a number of sources, all on equal basis, where to draw from primary rules in order to state the law. So the exercise, perhaps in the exercise of the ICJ, this is going to be more important. But I think that ITLOS, with the position it took, avoided having to address, one by one, the understanding that certain states had of its obligations under Paris, because it was not its task to clarify for them, their obligations under Paris. It was its task to clarify their obligations under UNCLOS. Thanks.
Thank you, Monica. I was looking at the Q&A, and there is a question with regards to environmental impact assessments. So I would like to give Ivano a chance to take this in the first instance, and then Monica, because I've seen you tweeting about this, Monica. So I would like to hear your views on the scope on environmental impact assessments and whether the cumulative impact, including the carbon footprint of all planned projects, should be assessed, evaluated, identified, quantified, and publicized with other parties. Yes, Ivano?
Hi, so I see the question is from Eline. Hi, Eline, from Media Defenses. So I think this is quite a very important question. I think that assessing the Scope 3 emission can be complex, as you know, due to the need for extensive data collection. And also it's important to analyzing this across the entire value chain, which might be a little bit tricky. That's why maybe it hasn't been extremely mandated yet. Also, as I said, data collection require coordination across multiple entities and transparency across the supply chain. And this, as we all know, could be really challenging to achieve. But on the other side, there are environmental standards and practices are evolving. So the explicit inclusion of Scope 3 emission in this kind of framework may follow as methodology and tools for measuring this emission become more robust and widely accepted. And so I would say that, yeah, the emphasis by ITLOS on cumulative impact opened the possibility, at least in my opinion, of including scope 3 emission in environmental impact assessment, promoting what could be a more comprehensive approach to environmental assessment. I don't know if Monica and Christina agrees on that. And basically the absence of this explicit mention likely stems from the complexity of the measurement and, as I said, the evolving nature of the environmental impact assessment practices.
Thank you, Ivano. Before I give the floor to Monica, just a heads up to Christina to start thinking about it. There is a thought-provoking question from Olivia. Do you think perhaps major CO2 emitting states will not start considering leaving UNCLOS to avoid future environmental litigation that may lead to UNCLOS proceedings? Yes, Monica.
Yes, thank you for the question. I was intending to address that in my initial address, but time was short. And I'm very happy that the tribunal picked up that point. And I say very proudly so because WWF made those submissions. So I consider that the cumulative effect is crucial. It hasn't been, raised before. The tribunal raised that quite interestingly and said, this is part of the considerations. The cumulative impact has to be part of the environmental impact assessment. And this is really, again, extremely important because it puts us really in a new era. The only tribunal that I know that has focused on cumulative environmental impacts is the Inter-American Court on Human Rights. And when we made these points, we refer definitely to scope 3. And I think you are quite right in questioning whether it will cover scope 3. Yes, because if you tie that to what the tribunal has said at Article 1942, I wouldn't just, tentatively say, yes, it may. No, it does, because the only way to regulate activities carried out both by public and private actors is to know what is the impact of the private actors' emissions, what are their emissions, and to be able to consider projects and the cumulative impact of various projects that may happen from public and private sources. You need to know the full impact in order to be able to see in what way that may or not create emissions that are prohibited by the way how the tribunal has interpreted the convention. So I would say we are in new brave world is going to be a major change gamer for the way how things have been operating at the regulatory basis.
Thank you, Monica. Yes, Christina.
Constantinos, before I answer that question, please allow me one brief comment to the previous discussion we had on the question whether ITLOS was mandated to interpret pairs or not. Of course, the jurisdiction of ITLOS is UNCLOS. That is, there's no question about it. But ITLOS itself ventured into interpreting pairs, right? It ventured into interpreting Article 2.1a as 1.5 degrees. It interpreted Article 4, paragraph 1 as net zero CO2 emissions by 2050. So it itself did go into interpreting the Paris Agreement in the context of giving meaning to the terms of UNCLOS. But it did not explain why it only went into these two provisions and none of the others, which may have helped in informing the standard of due diligence or what all necessary means are above and beyond the mere temperature goal and the timelines for net CO2 emissions. That was just my point, but I completely agree with you, Monica. Well, the question, could this potentially lead to a state party to withdraw from UNCLOS? Well, of course, the hope is not, right? I mean, just because the tribunal, which has jurisdiction over the treaty, has interpreted the treaty in its living nature, which it is because it has terms that can be determined and interpreted in the context in which they evolve. That should not lead to any state party to say, now that went beyond and now we withdraw. Legally, it is possible, right? It is always possible for states to withdraw from the treaties. But I think if that were to happen, that would come at significant reputational and political cost. And I really hope that is not something that any states consider, whether it is the European Convention on Human Rights or it is UNCLOS or any potentially other treaty that is now being interpreted in the context of that pressing global challenge of climate change. Shouldn't matter. I think states should live up to their obligations, which are of an evolving nature.
Thank you very much. There was a question posed at the very beginning of the session by Stephanie Prof regarding geoengineering. And I should say from the outset, this is of deep interest to me personally, because it's one of those areas where you have two conflicting objectives. You have the objective of mitigating climate change, but you also have the objective of environmental protection. So geoengineering and other ocean decarbonization technologies to abate atmospheric CO2 emissions and combat climate change may also implicate marine environmental obligations under UNCLOS. So I would like to open the floor perhaps to all of you, Monica, Christina, and Ivano. With that, perhaps we can start with Monica. If you have any views as to how to strike this balance between using technologies, ocean-based technologies, to mitigate climate change, but at the same time protecting the oceans from the deleterious effects.
Well, it is a hard question. I mean, let's not forget that the tribunal mentioned the precautionary, the precautionary approach generally in the tests of due diligence, somewhere in its advisory opinion, and also the importance of applying the due diligence test, taking into account the high risks that we currently face when it comes to the situation of the oceans. And also the final point that Christina had time to cover, which was the issue of the positive obligations when it came to the protection of the oceans, including the obligation to protection of rare ecosystems and threatened species. Maybe this is already tied into the other question there on deep sea mining, but to give you an example of how that may actually, these statements may impact that, because together with the precautionary point means that technology, and you could say even in deep sea mining, the whole idea is to extract minerals for good technology, green technology, to help the transition to a different world, but it cannot be done at the expenses of, in the way I am interpreting this advisory opinion, it cannot be done at the expenses of destroying, for example, rare ecosystems, threatened species in the ocean, if you take into account what the AO says now. So there is a huge task to understand, how to strike a balance on what you are saying. I think it's going to be done on a case-by-case basis, because there is going to be, there's a lot of issues that will have to be taken into account, including impact assessments. So it's not about just the principle. It will have to be also consider, specific issues, but we have now a guidance, and we have now, in a way, a new approach to that, because so far we didn't.
Thank you, Monica. Christina.
Yeah, no, my answer would have been pretty much the same. I think it really lies in the balance between Article 194 and the specific sources of solution articles a little later, 206 and so forth, and Article 192, right, where we have that general obligation to protect and preserve the marine environment, and where the tribunal went to great lengths to say it is about protecting ecosystem health, the natural balance of the environment, restoring degraded ecosystems, all that. And that's where it also brought in the precautionary approach and even a link to the Convention on Biological Diversity. So I think all this has to be seen in a comprehensive manner and to see where the balance lies and to what extent geoengineering or even solar radiation management activities, which could affect the heat aspect of pollution, now need to be balanced, but with the need to protect the ecosystem health of the marine environment. And I think there lies quite a lot of, and I agree with Monica, that probably has to be assessed on a case-by-case basis. But I think there lies a lot of research work ahead of us to understand exactly how to strike that balance.
Thank you, Christina. Ivano, a final comment as we run out of time.
Yeah, I think that much of what I wanted to say has already been said, but yeah, I think that in a way, this what is suggested is also we have to take into consideration existing principle of international law, as we said, the precautionary principle, but also the obligation not to cause transboundary harm, the duty to preserve and protect the marine environment. All of these apply to geoengineering activities, and also means that they must be conducted with a high degree of caution and respect for the environmental standards. So in a way, this is really something that, and probably we really need also more research and monitoring of this kind of technique to understand the potential impacts better.
Thank you, Ivano. Now, unfortunately, our time is up. We'll have to leave it here. There are many issues to be covered, and I think we will spend the next few weeks if not month, unpacking all the aspects of the opinion. Thank you for your questions. We managed to squeeze in a few questions. I'm really sorry it wasn't more. Please join me in thanking our wonderful panel. Thank you to everyone for joining this session from across the world. And thank you, as ever, for supporting BIICL. Goodbye for now. Thank you very much.
Thank you.
Thank you. Bye.